A blessed day to everyone. I am Lord Victoria Diaz, and today I, together with Stephanie Estrella, will be discussing the case of Liguez versus Court of Appeals at Alia with GR number L12240, promulgated on December 18, 1957. To begin, this case was filed by Conchita Liguez, praying that the decision of the Court of Appeals be reversed on points of law. The parties involved are the petitioner Conchita Liguez and the respondent's Honorable Court of Appeals, Maria Ngo, widow of Lopez, and the heirs of Salvador Lopez. I will now proceed to the facts of the case that determine the relationship that led to their legal dispute. The facts are as follows. Conchita Liguez filed a complaint against the widow and heirs of Salvador Lopez to recover a parcel of 51.84 hectares of land in Davao. She averred to be its legal owner pursuant to a deed of donation executed in her favor by Salvador. That Conchita was 16 when the deed of donation was executed. She had also been living with Salvador's parents for barely a month. That the deed of donation recites that the donor Salvador, for and in consideration of his love and affection for Conchita, and also for the good and valuable services rendered to Salvador by Conchita, thus by this resents voluntarily give, grant, and donate. Therefore, the donation was made in view of Salvador's desire to have sexual relations with Conchita. Furthermore, Conchita's parents would not allow Conchita to live with him unless he first donated the subject land. That the donated land originally belonged to the conjugal partnership of Salvador and his wife Maria Ngo. That sometime during June of 1943, Maria Ngo had met and berated Conchita for living maritally with her husband. That the widow and children of Lopez were in possession of the land and made improvements thereon. That the land was assessed in the tax rolls first in the name of Lopez and later in that of his widow. Finally, that the deed of donation was never recorded. As such, the Court of First Instance of Davao dismissed the complaint for recovery of land filed by the petitioner Conchita Liguez. The Court of Appeals affirmed the decision of the CFI of Davao. The respondent court held that the deed of donation was inoperative and null and void because, first, the husband Lopez had no right to donate conjugal property to the plaintiff appellant, and second, because the donation was tainted with illegal cause or consideration, of which donor and donee were participants. In view of this, the petitioner vigorously contends that the Court of First Instance as well as the Court of Appeals erred in holding the donation void for having an illicit cause or consideration. It is argued that under Article 1274 of the Civil Code of 1889, which was the governing law in 1948 when the donation was executed, in contracts of pure beneficence, the consideration is the liberality of the donor, and that liberality per se can never be illegal, since it is neither against law or morals or public policy. On the other hand, the respondents interposed that the donation was null and void for having an illicit causa or consideration, which was the plaintiff's entering into marital relations with Salvador P. Lopez, a married man, and that the property had been adjudicated to the appellees as heirs of Lopez by the Court of First Instance.
The issue of the case is that whether or not donation in order to pursue cohabitation is valid. Under the Article 1274, the flaw in this agreement lies in ignoring liberality of the donor esteem causa in those contracts that are pure beneficence, that is to say, contracts designed solely and exclusively to procure the welfare of the beneficiary without any intent of producing any satisfaction for the donor or the contracts. In other words, in which the idea of self-interest is totally absent on the part of the transferor. Yes, from the present case, it is clearly disputable that Lopez would not have conveyed the property in the question had he known that the appellant would refuse to cohabit with him, so that cohabitation was an implied condition to the donation and being unlawful necessarily tended to the donation itself. In the view of foregoing, the decision appealed from our revised and set aside. The appellant Conchita declared entitled to so much the donated property as may be found upon proper liquidation, not to prejudice the share of the widow Maria in the conjugal partnership with Salvador or the legitimes of the 4 heirs of the latter. That's all for our presentation. Thank you.